Excited about today's class. This is going to be a practice intensive class with some overview. I hope you're all feeling okay. So real property came up a few bars ago. We have landlord tenant as an area, a niche area that is tested quite frequently. And it came up quite recently in October 2020. So landlord tenant could come up. We definitely could have an easements essay again. We could have any one of these topics. So we have a sublease or assignment. And as you can see, look at how short the checklist of requisite areas are. The categories are not racehorse. These are kind of like, I don't know, maybe like 10 to 15, less than 15 categories that you need to know. Real property is definitely not a favored area for a lot of applicants. But I think it's not a favored area more for rule against perpetuities and the future interest, right? So typically now we do have very pure real property essays. You'll have an easement essay. You'll have like right to use the land of another, easement, real covenant, equitable servitude type scenario. You'll have a pure landlord tenant essay. So that is what the current trend is like. Feb 21, we're going to be looking at this one. This is probably the hardest easement essay. So we're going to be going over that one today. I want you to do this closed book. So let's get out the real property section of your material, volume 1. Okay. I'm not going to tell you where because I want to see your issue spotting. Okay. I've given a little hint. And I'm going to have you do this. I'm going to have you spend 15 minutes on this issue spot. There's a lot of issues here. Okay. So let's do your best. I'm going to share screen. You do not have this essay, so you have to do it off the computer. I'll give everyone a moment to turn to their real property outlines. Just kind of look up when you're ready, please. And I just want to say, you guys have this. Okay, cool. Everyone in the game, everyone in the zone. Thank you for being here. Let's pick up the energy and let's attack this real property essay. All right. Good luck. Please keep yourselves on mute. You have 15 minutes. Begin. Good luck. So on a scale of 1 to 10, 10 being the hardest, what would you give this issue spot? 7, an 8, 5. Raise your hand if it's higher than an 8 for you. Okay. Raise your hand if it's like 5 to 8. Less than 5? Okay. So it's medium to hard, right? I agree. I think it's actually pretty straightforward, but the structure of the answer would be the initial, how do I organize this, right? What are my issues? So let's do some issue spotting together. I actually issue spotted this morning. I hope my issue spotting is correct. I did check it against both models, and yeah, it was pretty on point. So let's get into it. Do I have any wonderful volunteers? Anybody want to tackle the first call of question? Anybody? Gabriella?
I'll try.
Okay. Thank you. So first of all, did you map out the parties? Did you do like a little map, a little road map?
Yeah, I mean, I have the worst handwriting, but I tried to like draw a map of the parcels so I could.
My map is pathetic, but I do think that you could not have gotten through this essay visually unless just reading kind of connects it without some visualization of the lane and the north property and the south property, right? And the use, kind of some labeling. So I definitely would have spent some time mapping this out and having party names. With real property, you get a lot of multiple party names at times. So this is a good example of that. So I would have definitely done some outlining. Okay, so what do we have going on here? Let's look at the first call. What rights and interests do Ed and Fran? Well, Ed wants to sue, right? Ed is our plaintiff, right? Do Ed and Fran each have in the lane? And may Fran, over Ed's objection, carry out her plans? Can you just give me like a brief summation, if you have to look at your notes or the facts, of what happened between Ed and Fran? What's their relationship?
So they're neighbors, and Fran is like north of Ed. She uses this lane for like, I guess, the people on her farm, the workers.
Whose lane is it?
It's Ed's.
Right. Okay. He's the owner of the lane.
Yeah.
Okay. And he's on the north side of the property. Okay. So Fran is above him. So she's even more north than him. She's choosing this lane. And what has she been using it for, and for how long?
She's been using it for 10 years. And she's been using it for like, she operates this farm with farm workers, so presumably they use the highway.
So right of way. To get on and off, to get to her property and get off of it, right? Okay. And what is she operating? She's operating a farm with a bunkhouse on it. So there's two parcels, so to speak, for farm workers on her land. She often used the lane to access the farm and the bunkhouse from the highway. Okay, so we have a pretty clear visual of what Fran's use is of Ed's lane, correct?
Yes.
Okay. And then I'm going to read, recently she announced she was converting her farm into a 50-lot residential subdivision and the bunkhouse to a computer service center. She informed Ed that she wants to run new electric lines and a fiber optic cable along the lane. So that would be a really big change in the right of way easement use, correct?
That's right.
Okay. So now she wants to operate some different things on there. So the question is going to be, so let's not even go to Henry yet. We're just really focused on these facts first, right? For call of question 1. Everyone see that? We're not concerned with 15 years ago yet. We'll just, okay, let's address 1. So now, if you can tell me what rights and interests do Ed and Fran each have in the lane, and may Fran, over Ed's objection, carry out her plans for the lane? What did you issue spot?
So this is an easement, and it's an easement appurtenant because
before you're on fire, but I just have some questions. Just to make sure everyone gets it. Where did you, obviously we have the right to way easement. The facts actually say easement, right? So what is the issue, like the question, if you were to formulate it in terms of, can Fran run these cable lines? What's the overarching legal question that we'll have to decide first to answer that?
I guess like what, like is she the servient or dominant tenement, or
well, I think what we'll have to do is establish the validity of the easement, see if it's potentially been terminated, right? And if it has not, is this change so far-fetched from the relationship, assuming it's valid?
Yep.
So to speak. Okay, so that's where the mind goes. Okay, great. Now take me away into the approach.
Okay, so
we have easement, right?
Yeah, and I identified it as appurtenant.
That's correct. Why?
Because they're neighbors, and Fran is using the lane to benefit her property.
Okay, so we need, and I'm just reading from the approach. It's appurtenant when it benefits its holder in his or her physical use or enjoyment of his or her property. There's two parcels. There's a dominant and a servient. So we have both of that, right? We have Ed's as the servient, Fran's as the dominant, right? So quick in and out, and we have this met. Okay, now where do we go pursuant to the approach?
For the creation of the easement.
Beautiful.
And I mean, I guess we can just state that like there's different ways it could be created.
I would just go into what you have.
Okay.
Yeah, I wouldn't go into, this is great. Like I wouldn't go into non-issues, just go to the type of creation that we have here. So if we look at the facts.
We have a signed written agreement. So
what is that?
That's an express easement.
Awesome.
Which requires writing.
I'm just going to go through the elements. Your issue spotting is on point. Do we have a writing?
Yes.
Do we have identifying of the parties and land?
Yes.
Do we have signed by the grantor?
Yes.
Great. And do we have the grantor's intent indicated?
I'd say so.
Birthday. Yes?
Yes.
Okay. And so your analysis on the intent also, is this an exclusive right?
We don't know that, I guess.
Well, we do know that Gloria, right, would use her property. Okay, so that's not really using it. So we don't have any language that there's an exclusivity here. It's not really that relevant, but yeah, okay, I just wanted to know. All right. So we established that we have an express easement created by express writing, and then where do we go for our next issue?
Whether the easement has been terminated. So
Beautiful. Okay. So what are we looking for here? Is
and
it is an easement typically of perpetual duration?
yes,
Okay. So,
unless indicated otherwise.
right. Do we have facts or proof as to termination here?
No.
Okay. So can Fran successfully argue that the easement right is still valid, the right of way? Okay. So no termination. Are you done?
Well, I would then state that like Fran has the right and she's the dominant tenant. But then I would.
So what's the question right now in your mind? Okay. So I have the validity of the easement, but what's the call? So you have to go back to the call of question.
Has
right?
the use changed?
Well, yes. Has the use changed? Because again, we've established the right that she can go on and off, but she wants to do something different. That's what Ed is worried about right now. That's what he doesn't want. So his right to sue her and prevail is going to be based on whether that change is reasonable, right? Or within the scope of the use of the easement. So there is a rule in change in use scope. It's on page 273 of your long outline. And the easement holder cannot expand the use if it is unreasonable. Okay. And you can get an injunction as well for that. So if they keep going, if the easement holder doesn't abide by the natural relationship of that easement for that period of time, especially a right of way, then you want to look at whether the change in use, the scope is reasonable. And here, is it or not?
No.
Okay. And what would your analysis basically be?
Like the original easement is just for the use of the lane for travel, not for putting, changing the nature of that in any way. So like
not to run electrical cable lines. Yeah. Right. So that's exactly on. So it's going beyond the scope of the easement is what I wrote. And the court is likely to find that the cable line usage is not within reasonable use of the easement and might even order an injunction. And you don't have to go into injunctive relief at this point. It just gives you a few extra brownie points to mention that. Okay. So underlying conclusion to the call is use is, unreasonable. Okay. So how many applicants, I'm just going to stop share for a moment, got the majority of those issues by show of hands? Beautiful. Good job. And if you didn't, just work through it. Okay. Just keep going. Work through it. All right. Who wants to take on call number 2? Great job, Gabriella. Really great job. Who wants to take on call 2? Anyone? Logan? I know you love this essay. Zoe? Chizzy? Sean? Come on. Take a chance. Philip? Katie? Sean? Reza? Anybody? Haley? Matthew? Shakira? Francis? Pereira? Terry?
I can try it.
Who said that? Oh, Logan. Okay. Thank you. Yeah. That's what we're going to do. We're going to just try. Okay. So so now let's go back to the scenario here. Tell me, Logan, please, what is going on with Ed and Gloria and Henry? What's the scenario here?
So it looks like Ed and Gloria had a covenant, possibly also an equitable servitude issue.
Can you elaborate on how you spotted both of those and why?
So I will say I definitely knew the covenant, and I just put the equitable servitude at the end because it seemed like he wasn't asking for any money. And he just
beautiful, right? He wants this not to happen, right? So injunctive relief. So, and also the language here where it says covenanted, right? So you
Yes.
know you're in a real covenant. You have to establish whether or not there is one. Okay. So keep going. So what happens?
So I started off with the covenant.
Well, what happens with Gloria? Where does Gloria live? I just
Oh.
want to like kind of set up the facts.
Yeah. Sorry, 1 second.
Just read it. 15 years ago, Ed and Gloria, his then neighbor on the south, so Gloria is now in the south,
Right.
had entered into a signed written agreement in which Gloria covenanted that she and her successors in interest would use her property only as a commercial organic garden, and in exchange, Ed would purchase produce from Gloria for use in his country inn. And then we find out that soon thereafter, that covenant, that agreement, that promise, Gloria sells her land to Henry, but Ed continues to buy produce off of the land. Okay,
Right.
so thereby continuing that relationship and agreement. Recently, Henry informed Ed that because Fran has all these plans for building and changing, that he wants to convert the garden, the organic garden, to a truck stop and diner, right? So we have a change in the potential agreement for that exclusive use of just being a commercial organic garden. Ed objects to Henry's, I'm skipping Fran because we already tackled Fran, intended changes and is suing. Okay, what rights and interests do Ed and Henry each have in the garden? So the question is, can Henry do this, right? That's the inevitable question. So why is easement not at issue?
Because this isn't really about like a property right or use of it. It's more of a promise to use something in a certain way.
Exactly. And also the language says covenanted, right? So we don't have the usage of easement like we did before. Okay. So walk me through the issue spotting, please. Two. All right. So what is your first heading?
Real covenants.
Well, I would just label it Ed, just like mimic the call, and Henry
Oh yeah, of course.
rights in garden property. Okay. So first, as you know, that's a summation. You don't have to give a summation in your essay answer. Ed and Gloria, 15 years ago, Ed wants to enforce the covenant and prevent Henry, the successor from Gloria, from changing his land into a truck stop and diner. We have a real covenant relationship as Henry is not a party to the contract between Ed and Gloria, right? That's also why we have to establish real covenant. Okay, so real covenant is first. We'll tackle that first. What are our elements, please?
So you have the requirements for the burden to run.
Okay. Well, okay. Are we going to start with the burden?
I started with the burden.
Yeah, I agree. Me too. Okay. So burden to run. And what is our first element?
There's 5 of them. The first one would be notice.
Okay. How many types of notice?
There's 3 types.
How many do you need?
I believe you just need 1.
That's correct. What do we have here? What type applies? Do we have actual notice?
Yes.
Why?
Because it was in the written contract with Gloria. She sells it to Henry. Ed and Henry still do the deal together.
That's the key fact, that he's still buying the produce, right? So we have actual notice. Yes. Do we have constructive?
I mean, I would say yes, but actuals more so.
Where would the notice have to have been of this relationship, this promise, for it to have been constructive?
If it was recorded?
Yes, in the property, ownership documents in the deed. So we
Okay.
don't have that. This is just a written agreement.
Okay.
No constructive notice.
Sure.
We already have actual, so we're good there. Inquiry notice?
That would be an inspection of the land.
Well, no, because we have actual.
Yeah.
So we don't have to even worry about it.
Okay.
Okay. So quickly in and out, establish if you have notice, and then where do we go?
To intent.
Okay. We have notice, intent. Okay, I organized mine. By the way, the organization is important, but it doesn't have to be in stone. So if you discuss privity first or so on and so forth, that's fine. Okay, so do we have intent? What is the intent? The original covenanting parties must have intended that the successors in interest be able to enforce the covenant. You look to the language of the original agreement.
Yep.
So is there intent for Gloria Henry's land to be subject to the produce covenant? Yes. Okay. Now where do we go?
And then we go to touch and concern. That's what I did next.
Good.
Um,
What are we looking for here? A covenant touches and concerns when it directly relates to the use and enjoyment, so the benefit of the land. And doesn't it? Does it? Does it
Yes.
benefit Ed?
yes.
Yes. Okay. All right. So where do we go next?
And then to everyone's favorites, the privities.
How many types of privity do you need?
2 vertical. I did vertical first and then the horizontal.
Great. Okay. Vertical privity exists between the original party to the covenant and the subsequent owner. In order to be bound by the covenant, the successor must hold the entire estate and land held by the original party. Did Gloria sell her entire interest to Henry, or did she keep some back?
Looks like she sold it all.
Yeah.
Yeah.
Everyone agree with that? Yeah. So we have vertical privity. Yes, Matt. What about, look at my issue spot. What about, it's just so like unilateral. Okay. Horizontal requires that the time the original parties entered into the agreement, the parties shared some interest in land, which is independent of the covenant. What do you think?
So this is where it got a little dicey for me. I didn't know if this was met because the 2 parties who agreed to the covenant were merely neighbors.
Right. So in the approach, it states, if the 2 parties who agreed to the covenant were merely neighbors, and one of the parties had no ownership interest in the servient land, then the covenant will not run with the land because horizontal privity is not met. Is that what's happening here?
That's what I put, and I said it was not met.
That is correct. So horizontal privity is not met here. The covenant must be set out. This is what my analysis said, which is correct. Must be set out in the conveyance of land, not just in the agreement. It was not in the deed or a land sales contract, and therefore no horizontal privity. And therefore, what?
It's not met.
So Ed cannot do what? What's your conclusion here on the real covenant?
He cannot enforce it.
That's
to
correct. So
Yeah.
due to the lack of horizontal privity, Ed cannot enforce the real covenant against Henry
Yep.
for damages. Okay. Now, like you said, correct. So no damages, no horizontal privity. Okay. I'll take questions in a moment. All right. So now we're going to look at, well, what about an equitable servitude? Because the facts state clearly.
I have a question, Shana, before we go into that.
Just hold the question.
Okay.
Let's
Okay.
just continue and then I'll take questions at the end. Okay, I just finished the issue spot. Okay, so equitable servitude. We're going to look to see, can an injunction happen? That's in essence really what Ed will want here, because
Right.
he's not going to want the change in for a truck stop. So what are we analyzing here? What do we not need that we needed with real covenant?
So we do not need privities here.
Okay, so we're going to go into the burden.
Yep.
Oh, what about the benefit, by the way? Maybe that was the question that was going to come in.
That was the question.
Okay, so,
Do I stop there?
well, what do you think?
I put it and tried to just quickly go through it, but in terms of timing, maybe I would just have written it down, and if I had the time, go back to it.
Who is benefiting? Who is benefiting in this scenario?
Henry?
Well, what is Henry getting?
I guess he's getting, like, he's purchasing things off of the land.
Ed is the one benefiting here. He's the one that's going there and getting his produce, and in essence would be the one that would have the court implement the real covenant and not allow for the change of the garden, right? So he's the one benefiting. So we don't need to go into the benefit.
Okay.
We need to talk about the burden. Okay. Equitable servitude. So for the burden to run, what do we need?
We need intent, notice, and touch and concern.
Beautiful. Okay. So we've already established these, have we not?
Yes.
So you would even just go same as above. Now, I'm not a huge proponent of same as above, see above, because they're literally exact elements. I'm okay with it in this scenario. There's no additional facts either. So same as above, notice, same as above, and touch and concern. Okay. So they're all met. Is Ed going to be able to enforce an equitable servitude and get an injunction that prevents Henry from running anything other than the commercial garden?
I put yes, that he can get the remedy, and then I went into the defenses though, and I talked about changed circumstances.
Beautiful. Okay. But I would go into the benefit here as well.
Okay.
Okay. So, okay. So just quickly notice intent. Okay. If you missed the benefit, it's okay. It's just both models had it. So it's a quick in and out. All right. And then the defense is correct, change circumstance. This would have been like a 15 to 20 point issue.
Yeah.
So if you didn't hit it, really study this area and the model and essay. But what is the argument here?
I put that the argument is that Fran was trying to change everything, and therefore Henry wanted to change because of that.
Okay. The changed circumstances alleged by the party seeking the release from the terms of an equitable servitude must be so pervasive that the entire area has changed, making it unfair to enforce the servitude. So in this call of question, we're not going into Fran. We're talking merely about Henry as the defendant.
Okay.
Right? So is there a pervasive the terms of an equitable servitude, we said it's met, we have an equitable servitude, must be so pervasive that the entire area has changed, making it unfair to enforce the servitude. So what do you think? We have a servitude that says you can only use this land for a gardening purpose. Is this a major, or has there been a major change? I mean, I think the facts with Fran are relevant,
Okay.
but the question is really against Henry as the defendant. So computer center not as farmland anymore? Is that a major shift? Is that a pervasive shift? Yeah.
I would say so, yeah.
Okay. So I think this analysis can go either way, to be honest. I think it's going to depend on, and that doesn't happen a lot, but I think you could really maximize your points. And I think, taking Fran's scenario into account as well, of whether or not she's going to be able to change it, and what it may be that there is an argument or a counter that maybe the neighborhood in general is making a shift, so it's not that big of a pervasive change. But I think it could have gone either way. I think you could have maximized your points, really just analyzing how big of a shift and change the move was, or the change of the characterization of the property. Okay, and what they're trying to do there. All right, amazing work. So the conclusion, the underlying conclusion is no real covenant, yes, equitable servitude, possible injunctive relief, and with a defense of changed circumstance that could pretty much go either way. Okay, great work for those for everyone, those that participated. So the key to this essay was, number one, mapping out the parties, understanding their legal relationships, and really seeing that you had an easement, a real covenant, and an equitable servitude. As you see, this is really a scenario where all you need to know are the essay approaches, right? A very little minor issue, it wasn't too minor, but a minor issue coming out of the long outline. But for the most part, this is a really nice kind of layout of the three approaches, but definitely difficult in the sense of, well, how does this all get carried out? So hopefully doing this, and by the way, this is a very unique fact pattern. They have not done this a lot where they've tested all three areas within one essay. That's why I love this practice. So if you didn't hit a lot, I would issue spot it again and again until you get it, okay? Because if you understand it and you can connect it, then you should be able to do that across the board. Yes, Zoe.
So when we're issue spotting, when we're looking for the facts for an equitable servitude, it seems like, if I'm understanding right, we're looking for where we kind of see the pattern for a real covenant, but there's something missing where it's not able to be met, but you could meet an equitable servitude.
So it more goes towards the remedy that the plaintiff would be seeking from the court. So when we're looking at a plaintiff that wants to argue or make an argument or have a stance that this easement or this, not easement, excuse me, not pursuant to your question, but this real covenant or this agreement, let's say promise, let's not even label it legally, should not be changed. We promise something, or there's a history here, there are other documents to support that, and we do not support a change. You want to look at how is the plaintiff being impacted. And if the plaintiff is losing money because of this potential change, then you're going to go for a real covenant. However, sometimes the facts they're not clear as to inevitably what the plaintiff would be seeking. In this instance, I think seasoned attorneys would know that injunctive relief is definitely, going to be the route. But when you have facts that don't say he wants an injunction, right? The plaintiff wants, then you have to go into both. So the key here was the equitable servitude, because inevitably he does not want the change in the property, right? He wants it to be used as the garden. But real covenant was still relevant because it was like a general call. So we're bringing in both. So you're basically looking for any legal concept that can support the plaintiff's position. Okay?
Yeah, so when they're seeking to like enforce it, that's a clue to go to like an equitable servitude. Whereas like
stop. Yeah, exactly.
Yeah, but damages is for more for equipments.
The cause of action is real covenant, like to enforce real covenant or to enforce an equitable servitude. But your damage, your remedy that's attached to that right is either money damages or injunctive relief. So you're kind of foreseeing and saying, like, if I was representing this plaintiff and these facts, does the plaintiff want money here? Well, sometimes, even if we have a plaintiff initially in the real world that wants the builder to stop, right? Like, you're blocking my view, right? You don't have a right to do that. Money sometimes speaks. So we can, negotiate and come to some settlement. But we want to kind of foresee, like, the first objective would be to get it to stop. Okay. So when in doubt, discuss both, unless the call is specifically only asking you for one. That's your
thank you.
Of course. Philip.
So should we have identified this as a negative or restrictive covenant? Because I thought that played into the change in circumstances argument you could make, since the whole intention from the onset was this to be only used for farming, and now you've changed the fundamental purpose of that covenant.
Do you mean a negative equitable servitude where it's like a common scheme or plan? Is that what you're referring to?
I meant also in the fact of the types. When we started the discussion, we identified it as a real covenant, but we didn't identify it as affirmative or negative. So I thought that we should identify the type as negative here.
Yeah, I think that's relevant. A minor issue, but I think it's relevant. I don't think it's an overarching, major issue. I think the key is to identify how it was created, and the elements required for it, but not the negative. We don't really have so many facts to identify it necessarily as a negative real covenant. We don't have.
Well, I thought the fact that they were restricting it to make sure it was only used as for farming makes it a restrictive covenant. So I thought that's why that issue became.
I think saying that it's a real covenant and that it actually is one is implied. But if you want that extra little label, I think that's okay. You wouldn't add dog points.
Okay.
If
But
you
you
label
don't think then that the fact that it is a negative or restrictive covenant plays into the equitable servitude argument at all? You don't think that there's any relevance to that from an equitable servitude standpoint?
For what purpose? Like what?
Well, for purposes of arguing that the fundamental purpose of the covenant was to limit its use, and now it has been changed from that fundamental purpose, and that goes to this change in circumstance. I thought.
But we still didn't have horizontal privity, which is an element. So
Sure.
So it's kind of like, so it's kind of like, okay, we can label it as such, but we still need that privity, that horizontal privity. So we're gonna rely more on the equitable servitude theory to back our case and not kind of harp on that. But yes, it definitely was a restrictive in that sense. Okay.